Good morning or good afternoon, everybody, and welcome to Macro Pro webinar series. I'm Diane Cohen, Vice President of Education and Client Relations for Macro Pro. I am joined by our friend Jennifer. Jennifer, how are you?
I'm good, Diane. Thanks for asking and thanks for having us.
Oh, you're quite welcome. Can you tell everybody what firm you're with and what today's topic is going to be?
You bet. I'm Jen McCaw with Siegel Moreno and Stetler. I too handle client relations and some educational pieces. Today with Tim Rose, our managing partner out of Northern Cal, we're going to be talking about applicant copy services and some strategies and different situations involving copy services usually used by the applicant side.
Oh, very good. So Jen, we have been starting out this summer school series with a question regarding summer. So do you have a question for our audience today?
I do. I was thinking about this last night, and I was just wondering what our audiences usually like to drink. Typical Jen question. The beverage of choice for the hot summer months. I was thinking mine probably is a splash of tequila with a salted rim with a little bit of lime juice, especially if my toes are in the water somewhere and it's 80 degrees. Look at everybody's going, yeah. Oh, water and kombucha. This is tequila with lime. Chuck is my guy.
Yeah, totally. Fresh lemonade at the pool, that's another one.
Yeah.
Yeah. Well, so mine would be a lava flow. If I'm somewhere tropical, I want a lava flow, right? Pina colada with some strawberry goodness inside of it. So for those of you in the audience, we still would like to see what it is that you'd like to drink. So while you're typing that in, and Jen will look at that in just a minute, I'm going to do a little housekeeping. First of all, today's webinar is worth 1 CEU credit. You will receive that from GoToWebinar in approximately 1 hour. You need to be logged on to the system in order to get that, meaning you had to use their link. If you use somebody else's link, the certificate's going to show up in their name, not yours. So make sure you use your own link. In addition to that, if you have any questions today, you can put it inside the same place you're telling us what drinks you like to have is the same place that you would be able to ask questions. And we do have handouts for everybody today. So please be sure to download those now. Now, earlier today, we had the applicant side that discussed all things copy related off of their side. Now we're going to have it based on the defense. If you missed one of these, be sure that you go to the Macro Pro YouTube channel because both of these programs will be on there tomorrow morning. So Jen, I am going to give this over to you so you can introduce Tim.
Great, thank you so much for that. And coconut water, that sounds good. And beer, Emilio, yes, a good beer too. Watching the Padres, go Padres. Again, I'm Jen McCaw with Siegel Moreno and Stetler. We are a workers' compensation defense firm. We also do some subrogation services. Tim Rose is our managing partner out of Northern California. When Tim is not repairing a car or rebuilding a motor on the weekend, he is preparing and doing training sessions for everybody because he loves these types of trainings. And this particular topic on copy services, I will brag a little bit about him. He is somewhat of an expert and has done several trainings on. So feel free to jump in there. If it'd be nice if we can like have an interactive session, and we'll try to get to your questions as you ask for them because sometimes it's nice to ask the question and when we're discussing that topic. But anyway, so Tim is a little bit of an expert on this topic, and I think we're all going to enjoy that session, this session. And with that, I'm going to turn it over to Tim.
All right, thank you very much, Jen. I appreciate it. Hopefully everybody can hear me okay. We are going to have a little bit of fun today while we talk about a topic that's near and dear to my heart. Couple of disclaimers before we get started. Number one, all of the opinions, thoughts, musings, things that we're going to talk about today are of my own. They do not necessarily represent any views of the particular firm that I am employed by. However, I am fairly certain that if there's any attorneys out there that are viewing this, you may have some similar opinions and findings. Second, this topic is something that I have litigated quite a bit over the last 15 years of my involvement as an attorney. And it was also something that I addressed when I was an examiner before I became an attorney for 6 years. I was counseled or asked to provide some information by the state legislature when they were first talking about the copy service fee schedule. I have met with various examiners, supervisors, copy service professionals over the years. Everything that you're going to see today in the presentation is something that I have litigated in some form or another at various boards throughout Northern and Southern California. I believe that I have actually tried a copy service lien at every single appeals board except for 2. And so I have been able to see kind of how different judges interact with some of these arguments. Finally, I may actually go on mute from time to time. I'm dealing with the end of a cold, so I don't want to cough in anybody's ear. So if I take a quick break to grab some water, I hope you will understand and not be sad that I may mute myself for just a quick second. Okay, so the topics to be covered, there is a total of 7 of them. They kind of mesh. Some of them are going to be discussed in a little bit greater detail than others. As Jen mentioned, this is an interactive process. They are going to be fielding some questions. We may actually answer some of those questions as the topic is being discussed. However, if somebody has a question that they would like to wait till the end, that's fine as well. We'll do our best to accommodate everybody and any questions that you may have. First, we're going to talk about history of the legislation and relevant case law. We're going to spend actually quite a bit of time on that because it overall dovetails nicely into some of the potential defenses, some of the potential arguments, things that we may go through if we take a copy service lien to trial or have to litigate it. We're going to talk about discovery needs and the involvement of copy services. Are they necessary? If so, why? We're going to talk about management and administration in relation to claims. That's going to be some more information directed towards claims examiners, supervisors, carriers, TPAs, that type of thing. We're also going to discuss about the misuse of the subpoena process and some of the tactics that copy services and applicant attorneys have employed over the last few years, especially since the implementation of the fee schedule and some of the changes. We're going to talk a little bit about reasonableness of costs, and finally, best practices. What can we do to address copy service bills that are excessive or otherwise inappropriate or unreasonable? Now, to start, I want to go back in time to before 2012, which I call the Wild Wild West. At the time, there was no set fee schedule in place. There were no set rules on copy service obligations. The responsibility of the parties was not really well defined. We would have subpoena services issuing subpoenas at any time for any reason. And even in the face of that, the defendant was still responsible for those charges and litigation associated with the billing. Charges were completely subjective. I had had some copy services on the applicant side that were very reasonable in their costs. I had some that were completely outrageous. There was one of the big players that's no longer in existence at the time that had astronomical sums for certificates of no record, minimal records copied, things of that nature. And I would get complaints from examiners all the time about, why is this so expensive? Do I have to pay for this? What can we do to litigate this issue? I don't feel that it's reasonable. And so there was a lot of trial and error when it came to potential litigation strategies involving those various copy services. Some of the things that I noted over the years, and I've put them down here, they included a base rate. It was never established what that rate was. It was just simply for opening up a case to issue a subpoena. Bait stamping, extra copies, discharges, phone calls, mileage. I would frequently see something listed as miscellaneous, although it wasn't ever defined. And then pagination. All of those were things that were lumped into an overall bill. One particular example that is near and dear to my heart, I once took a copy service lien packet to trial in the Riverside Appeals Board. They had a total of 42 subpoenas that were issued over the course of about 8 months. And in those subpoenas, they included a request for pediatric records for an individual that was in her 50s. There were some locations that at the time of trial, they could never even tell us what they were being requested for. There was no rhyme or reason. I ultimately took all 42 of those to trial. We prevailed on 37 of them, and the remainder we ended up reaching an agreement to settle. One of the highlights that I noted was there were $350 bills for certificates of no record, and one bill had $450 for a total of 5 pages copied. It was a really good opportunity for me to see kind of how a copy service operated when it came to some of the charges and some of the arguments that they would make. And I know that the judge was really kind of exacerbated about actually having to go to trial on this issue. It was a very lengthy opinion, but overall we did pretty well. But it was just a great example of something that I saw that definitely knew, I definitely knew there's got to be some sort of change that has to be made. So back then, when we would have some litigation and potential liens that would be filed, we would object to a subpoena for the most part. We would file a petition to quash most of the time. The defendant would issue an objection in EOR or EOB form or in writing with hopefully what would be a substantive objection. Arguments from the lien claimants were not necessarily over reasonableness of the subpoenas themselves, and even if they were necessary, it was simply, hey, the applicant has a right to litigate their claim. We were just doing our job. Applicant's attorney made this request. We're just following orders, so forth and so on. And even with clear objections, procedures issued timely, copy services would turn around and file liens and argue that there was always something else that the defendant could have or should have done, and as such, their services were warranted. I, again, recall that no matter what it was that I had said or what some of the attorneys that I worked for had said, they would indicate that there was always something else that could have been done. And that was, in essence, most of the argument that they would make to the judges. We also ran into multiple situations, we still do from time to time for lien claimants, where we would have a host of lien claimants that would file liens. We would get down to a lien conference. It may have been filed by the defendant, may have been filed by the applicant, a lien claimant of some kind. And we would get down there and all of a sudden there would be a new lien claimant that would surface. It would be a copy service most of the time. And there would be instances where we would actually set it for trial. We would show up for trial, and then there would be a new lien claimant that would surface at that point. And so everything would be taken off calendar or continued. We would have to reserve documents, and we would, in essence, kind of start that process over and over again. Demands would be made for documentation, which they're entitled to, legal, medical, benefit printouts, employer files, and when I would ask, well, what is this necessary for? How is this in relation to your copy service lien? The answer is that they are entitled to that information, and that was pretty much the long and the short of it. So we would go through an exhaustive process of serving that documentation, and then even after that, it wouldn't be used, or they would indicate that something else was missing. They would question if we had actually served everything, and it was just problem after problem and delay after delay. So then we'd finally get to the lien trial process, and lien trials still to this day are often continued or otherwise delayed. Unfortunately, with the way the appeals board works, lien trials are basically the lowest on the totem pole. So we may have an instance where every lien claimant shows up, all of our witnesses show up, we've got bill review experts, we've got everybody's ready to go. But because there's a couple of other appearances ahead of us, we get continued. I had a lien trial in Southern California that had been continued 5 times involving a copy service lien. We had 5 times that the lien claimant showed up, their expert showed up, our bill review person showed up, I showed up, and yet we were continued time after time after time. And so finally, I ended up having to go to the presiding judge saying, isn't there something that we could do? This is getting ridiculous. We've been talking about this for 2 years now. We all want to go forward. Let's just go ahead and get this done. So then in 2012, there was a change that really was, in my opinion, kind of monumental. And it was monumental for a number of reasons. When they were first talking about establishment of a fee schedule and exactly what would be allowable in terms of services, I was actually contacted by a few state legislatures or legislature men and women, and they actually asked me to come in and talk to them and to give them my opinion, and so I did. One of the questions they asked was, well, how do we solve these potential problems? And my initial response was make applicant attorneys responsible for improper subpoenas and improper copy service. If we did that, it would solve a lot of problems. They, of course, immediately nixed that, indicated that there would clearly be some discovery issues. There would be some rights that would supposedly be violated. It would kind of chill the discovery process. And so I said in response, you asked for my opinion, but if you want other substantive measures, then we should really be looking at reasonableness of charges, the ability to respond to subpoenas, the responsibility of the parties needs to be identified, a fee schedule needs to be put into place and somehow. And so through all of the negotiations, they came out with SB 863, which later turned into Labor Code 5307.9 and then 8 CCR 9982. And what that does is it required the administrative director to adopt a schedule for fees payable to copy services and related services. The schedule applies regardless of claims filed under either 4600, 4620, or 5811, or any other authority, save there be a contract between the employer and the copy service provider. That does happen from time to time. I do have a couple of cases where that is involved. And because of that contract, the fee schedule is kind of set aside. 9982 addresses what are allowable services, and it also addresses the responsibility of the claims administrator to serve records under 5307.9. The big takeaway is that the defendant now has an opportunity to properly comply with a request for service of documents from applicant's attorney. It gives them what I believe to be a reasonable time frame in order to respond. It gives them an opportunity to put together all of the requested documents and to timely serve it on applicant's attorney, thereby avoiding most of the need for initial subpoenas. It also says what would happen if the claims administrator fails to do that. Claims administrators are not perfect. Examiners have heavy desks, and sometimes it's difficult to comply with requests. Sometimes requests come in and they're not immediately received. Examiners go on vacation. There are some desks that have transferred files, things of that nature. But this, in essence, gives us a reasonable time frame to issue a response to a request for documentation from applicant's attorney. The big takeaway is that they have 30 days for service upon written request, and some of those other charges that used to exist before 2012, which include summaries, indexes, tabulations, things of that nature, those have gone away. So now we have copy services also being identified under Labor Code 4622 as a medical legal expense. This was one area that was somewhat confusing because on one hand, copy services aren't really a medical legal, and on the other hand, they are because they are used in the medical legal process. There was a lot of confusion as to how exactly you would classify a copy service, and so the legislature put together a labor code provision that in essence indicated that they are now under the medical legal banner. In my opinion, that makes sense, and I think it actually allows for a little bit less confusion when it comes to how you process an invoice, what objections you have, the litigation process in the event that you have to litigate those copy service bills, things of that nature. I put the Martinez versus Terrazas case that is, in my opinion, one of the best explanation cases for why it's a med-legal, what's classified as a med-legal, and things of that nature. Now, under subsection B, if there's only a contesting of the amount paid, say the copy service does the services that they're supposed to, they comply, but they bill too much, then the defendant can issue an objection. They can pay the amount that they feel that they're obligated to pay, and issue an objection to a response to request for payment. And then if there's a disagreement, the copy service can request a second review within 90 days. Otherwise, the billing is deemed satisfied. Now, one of the questions that has come up in the past with some of the cases that I have handled is, well, what if it's an objection that's not an EOR or on an EOB form? Every TPA or carrier has a set form that they utilize. However, there are some examiners, quite a few that I work with, that actually draft more handwritten substantive objections. And in those objections, they specifically put what exactly the service is, why they are objecting to it, the basis for it. They even include maybe labor code provisions. I've even had some that include relevant case law. It has all the trappings of a form EOB. And I have had a couple of copy service providers that say no, because it requires this document specifically. That's no good. I have taken that issue to trial. I have had judges determine that if it contains everything that's necessary that you would normally find in an explanation of review or explanation of benefits, then it is in fact appropriate, assuming of course it was issued timely and to the proper party. Now, if there is an objection and the defendant responds within 14 days and there remains a dispute, the copy service provider can request an independent bill review. But now let's get into what happens if there is an objection in its entirety. What happens if we don't feel that the copy service was valid from the very beginning? If we object to services in the entirety other than the amount paid, then now we go down to subsection C, and this is where the potential litigation applies. It's the non-IBR process. So what we have is a copy service provider submits a bill, defendant reviews, issues their timely objection, says we're not going to pay for it. Once the defendant issues an objection, the provider may object to that within 90 days of service of the explanation or EOR. I have had that objection come in the form of a written objection through letter. I've had it come in through a request for a second bill review. In essence, if there is an objection of any kind that is reasonably construed to be an objection to the original denial for services reimbursement, then every examiner should treat that as an actual denial. So that way it's clean, it's concise. If you have any questions on the safe side, I would treat it as a request for an objection, or sorry, an objection. Now, if we have that occur, we are on the defendant side is supposed to file a petition for non-IBR and a DOR for an MSC within 60 days of that objection. Now, one of the pitfalls that the defense side often walks into is oftentimes defense attorneys don't see what is going on with regards to standard bill review, standard objections, things of that nature. They may not even get a copy of a copy service bill. Most of the time, copy services are pretty good about providing billing to defense counsel, but there are times when it doesn't come in, or sometimes it's sent to the employer, sometimes it's just to the examiner, sometimes all three. But if there is an objection lodged, oftentimes the defense attorney doesn't actually see it. And so it becomes a little bit of a guessing game as to when did the EOR go out, what was the basis for the objection, and if we get a request from the copy service telling us that they are objecting or to take another look, that clock starts ticking on filing that petition. And so defense attorneys have to be kind of on their game and making sure that they are maintaining regular communication with claims examiners. And on the other hand, claims examiners have to make sure that they're maintaining regular communication with defense attorneys. Fortunately, there is a little bit of a save The Ashley Colamonaco decision versus Secure Transportation, in my opinion, it was a very important case because it eliminated a lot of problems while at the same time providing fair warning to the defendant that although it kind of saves them from some mistakes, at the same time, you have an obligation to be proactive on your files. So in essence, what the Colamonaco decision did is it clarified the burden that copy services must provide and must overcome in order to validate their services. And it also provides some potential defenses for the defendant. So the first question is the claim actually disputed or contested under Labor Code 4620? Copy service has the burden of proof. I cannot tell you how many times I have had an appearance involving a copy service where they said to me, disprove it. No, that's not the burden. I don't have to do anything. You have to prove whether or not this claim is disputed or contested. Denied claims or claims with disputed issues makes it a little bit easier, but then it begs an interesting question. What exactly is the disputed issue? I have had some copy service lien reps or representatives indicate that if the entire case is denied, that's good enough. If there is a denial of a single body part, that's good enough. If there is a denial of a particular request for treatment, that in and of itself is good enough. And to that I say no, that is not actually good enough. We need to take a deeper dive into truly what is at dispute and if the copy service is actually related to that dispute. Number two, where the expenses occurred for proving or disproving a contested claim. Again, what is the issue that we are arguing about at this point? And number three, are the services reasonably, actually, and necessarily incurred under Labor Code 4621? Continuing on with Colamonaco, we again need to take a look at what exactly is the copy service copying and for what purpose are they copying it for? Sometimes that requires us to kind of get into the mind of applicant's attorney. I know that sometimes it's relatively straightforward, but oftentimes it really isn't. Colamonaco stands for the proposition that the defendant does not necessarily waive an objection based on 4620 or 4621 if they fail to raise those objections by 4622. However, that does not mean that you can just ignore the process and say, well, Colamonaco kind of saves me. That is not the case. You still have a duty to make good faith objections and to clearly note your objections and what exactly it is that you're objecting to, and to go through the process to assert your defenses. The issue again over who has the burden, it falls under the copy service for compliance of 4620 and 4621. Excuse me. 4620 is whether or not the employer knows or reasonably should know of a claim for work comp benefits, and the employer denies the claim outright or fails to act within a reasonable time frame. If it's a denied claim, it's pretty straightforward. If the employer has knowledge, again, relatively straightforward, but there are those instances where claims are not timely reported. They're reported to the wrong employer. They're reported to the wrong address. I had a lien or conference that ultimately resulted in a trial where I took a copy service and a couple of providers to trial because the original application of adjudication was sent to the correct employer at an incorrect address out of state and then an incorrect TPA. And when the TPA notified the applicant attorney, hey, I think you sent us the wrong case. We don't have this file. We don't work for this employer. They again sent it to the wrong employer address and they sent it to the correct TPA, but they had a PO box on the application that was different than a PO box for the proof of service. And the PO box on the proof of service, which in my opinion was the one that was most important, also did not go to that TPA. And our entire trial was actually over whether or not the employer actually had proper notice, or the TPA, or anybody that could potentially file that claim. And ultimately, it was determined that no, in fact, they had not met their burden by demonstrating that the employer knew or reasonably should have known. Now, under 4621, the provider, or in this instance, the copy service, has the burden of proving that the service is reasonably, actually, and necessarily incurred. So the focus that I usually direct my attention to when we're going to litigate this issue is, what is the time frame for this service? What is the reason that there was a request for subpoenaed records at this point in time? You may still have a denied case. We may have actually done a bunch of discovery. We may actually have other subpoenas that were generated. But what is it at this moment that would generate the need for a copy service to become involved? Are they simply issuing blanket subpoenas because applicant attorney requested them? Are the locations of any importance? What exactly is going on that would prompt the need for the copy service at that exact moment? That goes back to the argument of whether or not they were reasonable, necessary at that point in time.
Hey, Tim, it's Jen.
Yeah.
I'm going to jump in with two questions
Sure.
from Nelson Garcia. One was a little earlier, but is following along the lines of what you're discussing. If a provider fails to copy the defense attorney on the objection, does this make their objection invalid since the DA was not copied and they are the legal representative? That's question one.
Okay, well, I'll answer that one first. Yeah. I'll give the lawyer answer. It depends. I have had judges that say that if the defendant or if the defense attorney is clearly identified, whether it's on EAMS or other documentation, then there was no proper service. But most of the time, the appeals board, which takes a liberal construction, will generally allow for something like that to get through as long as the claims examiner or TPA or carrier is properly notified. I'm not aware of any statute or case law that says it has to be provided to every single party, otherwise it's completely invalid. I don't think that that exists, and I have had some judges, I've made that argument, but I've had more than a couple of judges ultimately say no, if it goes to the examiner and it's verified that it made it to them, although it was improper, sorry, we'll deem it to be proper service. But I would always still make that argument because that can be used in terms of negotiation.
Okay. Second question, and then one more just because we're right on topic with this. Do objections from defense require a proof of service? I mean, we always have proofs of service on everything, but require is the word.
It's pretty rare that a proof of service, at least in my office, doesn't go out. I have had instances where there have been claims of service not actually being initiated, whether it was they claim, oh, we never got the letter, that letter was never sent, so forth and so on. To get around that, I've actually had my staff sign affidavits basically saying this is my normal practice, this is my normal procedure, this is how I provide service of documentation. I do declare under penalty of perjury that I served this letter to this person on this date and this time, and that is passed muster with the WCAB. I am not aware of a requirement for a proof of service, but I would say in order to make sure that we are all on the level and we're not dealing with any problems, that you generally include proofs of service with, I would say, correspondence that could potentially be controversial.
Right. Okay. And I don't want to derail the entire thing. Last one on topic, and then we'll move on. How about copy service subpoenaing records only for the purpose to complete an IMR applications on behalf of an attorney, any attorney?
Oh, we'll actually talk about IMRs in a couple of minutes, and okay. I'll give you a couple of examples. So if you could just kind of mark that, and we'll go back to it in just a little bit.
Great. Thanks, Tim.
Okay. So moving on, let's talk a little bit about discovery and the subpoena process. Now, I have had some copy service providers state that my position is that they are not entitled to services and they are not entitled to the discovery process. And I disagree with that. I use applicant-oriented copy services from time to time. I will occasionally get records from them. I will occasionally ask for them to provide me with copies of records. So the applicant does have a right to discovery and the subpoena process. The question is whether or not the defendant has to pay for it. Is it reasonable? Is it something that somebody else is now required to pay for? That's where we kind of wade into the gray issues. Now, the right to discovery, it's very broad. It's to be construed liberally. And the Williams v. Superior Court case that I have noted really kind of drills down on what type of discovery is considered reasonable and what that liberal interpretation is. I listed a couple of different evidence and labor code sections, as well as a California Code of Regulations section that discusses what types of things can be subpoenaed. We've got, copies that can be used as originals. Again, a copy service is providing a copy to somebody. Inspection of personnel records, review and inspection of medical records, diagnostic studies, things of that nature. So we'll start from the premise that the right to discovery is pretty liberal. Now, copy services must also be provided in accordance with the applicable codes and sections. Are the subpoenas under 1985 issued appropriately? Do they contain the appropriate documentation? Are they sent to the appropriate parties? 1987.5 allows for an order to show cause in the event a medical provider does not comply with a subpoena request. And Government Code Section 68097.1 discusses the use of government involvement and government subpoenas. Now, continuing on, under Code of Regulations 10626, subject to Labor Code 3762, and unless as otherwise provided, all parties, attorneys, agents, physicians are entitled to examine and make copies of physician records, hospital records, dispensary records, or records that are relevant to the claims process and for issues pending before the WCAB. So again, that's pretty wide open. But again, does that necessarily mean that the defendant has to pay for it? Labor Code 5708, it does allow for claims that are not necessarily bound by common law or statutory law in evidence and procedure. So I'm sure any examiner that's been around for longer than 6 months knows that rules are very flexible and liberally construed. I have handled civil claims in the civil arena from time to time, and the discovery process is vastly different than that in the workers' compensation arena. Now, it's based on this general assessment of discovery rights that copy services generally operate, but it's not unfettered. Again, 9982 provides a 30-day waiting period to provide records. If the defendant serves that documentation within the time frame, subpoenas are not to be issued, and if subpoenas are issued, the defendant is not liable for payment. Records copied after service of records by the defendant are not subject to reimbursement. The Janai case, I think that's how you pronounce it, is something that I have relied upon time and time and time again, because what I run into most common is the defendant will actually comply with a copy service request. They will actually issue the records properly. They will actually serve them. Everybody seems to be happy. And then all of a sudden, we get 4 or 5 subpoenas from all of the locations that were just served. And my position is, if we have properly complied with that request, we are not subject to reimbursement under this decision. Defendant is not liable for payment if those records were previously obtained by subpoena or authorization by the same party or source. Now, let's talk a little bit about that IMR issue. One of the things that I have seen applicant-oriented copy services do is they will offer a service where if there is an IMR objection or a denial, and UR denial, and they want to start the IMR process, they will simply reach out to the copy service and say, hey, we've got a UR denial, go to work for us. And all of a sudden we'll start getting subpoenaed records or subpoenas for records from various locations. And the argument that they make is, well, number one, there was a request for service at the very beginning of the case and the defendant didn't provide anything updated within the last 45 days. Number two, the defendant might not have all the records that the IMR will need, and so therefore we are going to issue those subpoenas. Or number 3, these are kind of updated subpoenas, if you will, because we don't think that the defendant actually has all of the records in their possession in order to send it to the IMR process. To that I say that is inaccurate, and I don't believe that that is an appropriate means or reason to issue a subpoena. First and foremost, the defendant has to provide 6 months worth of records going back. That's a requirement. The applicant can certainly provide the same 6 months of records if they choose. The first question I usually ask copy services is, what evidence do you have that the defendant is not producing all of the documentation? That's number 1. Number 2, what evidence do you have that they don't actually have all of the records? And number 3, how could they not have all of the records if the most recent treatment request is the one that is actually subject to the IMR process? What evidence do you have that any of those things justify the need for a subpoena? And most of the time, I get a response that they have a right to gather these records, and we just feel that something is missing. Another thing I will notice is they will occasionally issue updated subpoena requests, and they will only put the dates, like a date from and to, and it's the date from the last time a subpoena has been issued on that case for that particular location. And the response that I will usually give is, what is the relevance of that treatment location to this process? I have had copy services that will issue subpoenas for records from providers that have not provided records or treatment for years. They provided care at the very beginning of the case. They haven't been involved in this. They wouldn't be involved in the last 6 months. And yet all of a sudden there's a subpoena requesting updated records from them when they haven't provided treatment in a number of years. So to kind of go back to that question, it really kind of depends on what is being requested, and again, for what reason. Is there any valid basis for that copy service to have to go out and obtain those records if the defendant has previously served them, if they've provided updated file and serves to applicant's attorney, or if there really is something missing? Once in a while, we will get a secondary physician that maybe hasn't issued updated reports in a while, or something was missed by the claims examiner. But I make it a point to usually issue an objection and sometimes even file to quash quite a few of those subpoenas for the IMR process.
Hey, Tim, it's Jen again.
Yeah.
Okay, so what are your thoughts? Do you think there will ever be a statute of limitations on non-IBR petitions? And then I've got a second part of that question as well. And then I've got a good case question as well.
Well, I'm not exactly sure what they mean by a statute of limitations for non-IBR petitions. If you're asking if there is a statute of limitations in order to file one or in order to litigate one, I don't know if there ever will be, so maybe that person can clarify that question. So
okay.
How about if they clarify it and then we'll go on to the next one.
Oh, okay, so let me just ask too. So the second part of this is the lien rep argues that the applicant attorney doesn't have to demand or didn't have to demand records at least 30 days prior to the SDT unless defendants served the records at least 30 days before the SDT.
I'm not aware of anything in any statute or case law or authority that would support that claim. Most of the time, the arguments that I get are the original notice of representation lists a continuing duty to serve, and therefore it's in perpetuity. I would say that that's questionable at best, but usually what I tell my clients is if they are in compliance with whatever internal regulation to serve and continuing duty to serve, once we get that subpoena, we're going to treat that as a request from applicant's attorney to serve updated medicals. And so I will comply with the request and I will serve those medicals, or my client will, directly on applicant's attorney. But that doesn't mean that I'm complying with the subpoena itself.
Okay.
It specifically says there's got to be a demand and the defendant has to be given time to respond. And if the defendant is doing routine file and serves or updated file and serves, I don't see how that alleviates the applicant attorney side from making a request for updated documentation if they somehow feel that something has not been provided. I also say, well, let's take a look at the history. Has applicant attorney suddenly issued subpoenas randomly throughout this claim? Or is this simply over a recent event? And if that is the case, which it usually is, are you really making a valid argument at that point? So I understand the defendant has a continuing obligation to serve, but at the same time, I think that applicants' attorneys have an obligation to make a request as well, and I will often treat those subpoenas as that request.
Okay, I just wanted to ask one more, and then we've got some really solid questions, but I'll let you move on and we'll circle back. What about fees for copy service companies to fill out the IMR, then send the records to Maximus? This sounds like an applicant attorney in San Diego that will remain nameless.
Now, did you say bill out the IMR?
Yeah, so they charge defendants to fill out the IMR and sending the records, the package to Maximus. Is that
to fill out the IMR?
Right, to actually fill it out.
Yeah, I know who you're talking about. I thought you said bill out the IMR. I have actually litigated that issue in terms of the actual completion of the IMR application. I am, again, not aware of any case law, statute, labor code provision, anything like that that allows for copy services to perform what I would argue is a legal service acting on behalf of the applicant directly. I think that kind of wades into representation. I have a current case that's being litigated over agency, over whether or not a copy service is an agent of applicant's attorney, and if so, where does that agency exist and where does it end? But the argument that I have made with regards to any type of billing in that nature is you are not acting on behalf, you are acting on behalf of applicant attorney for a limited service. That does not mean that you are filling out forms on their behalf of a potential legal issue. And so therefore, there's nothing in that I'm aware of in the fee schedule that allows for that type of billing to be allowable or processed.
Okay. Okay, we've got some solid other questions, but I'll let you move on since making sure we're watching the time. Thanks, Tim.
Yeah. Okay, so kind of moving pretty quickly through this, we have a continuing duty to serve under 10635. Requires the defendant to provide benefit printouts and outgoing service of medical reports within 10 days of receipt, but that goes both ways. Applicant attorneys have an obligation as well. Most TPAs will have a general file and serve protocol, which I think is reasonable. I also point out that there are multiple opportunities for the applicant to receive records, and it goes above and beyond what a standard file and serve entails. For example, if we have an IMR request and the defendant provides 6 months worth of medical, they serve it on applicant or through their attorney. QME, AME, or IME evaluations. A lot of the time for the first one, we have to serve everything, including prior subpoenaed records. In my opinion, that creates a proper service to applicant's attorney, and we have actually complied with a continuing duty to serve. New treating or secondary physician designations. Sometimes we have to send the entire medical file. Sometimes we'll get a request for individual documents from those same doctors. And then also in particular, we're supposed to serve documentation prior to an MSC. And so all of those create opportunities for the defendant to continuously serve and to thus kind of negate the process or the reason for a subpoena from being generated. Now, some of the misuse and tactics, we have the creation of a fee schedule and rules they must abide by. It was not well received. I know some copy services were saying we're going to be out of business. It simply lists issues at dispute on the application of adjudication. That's a big one. A lot of the times applicant attorneys will have no idea what's at dispute. They just file a blanket application. They list all issues. Labor Code 4620 specifically does not include listing an application issue as or application of adjudication dispute as something that would validate a subpoena. Any issue that could be or even is a dispute is not necessarily a reason for a copy service to be involved. And again, Labor Code 5811 no longer seems to be an option for copy services, which again was not well received. So how can we have misuse or abuse or ignoring of the Labor Code? I have had instances where copy services will issue a post-dated subpoena. They will issue it the same day the notice of representation goes out. I have had, and then basically say, well, we're just following up. In my opinion, that's improper. I've already spoken about number 2, where subpoenas will be issued after timely and proper service. They will claim that there is something hidden or not being provided with no proof. They will again indicate that that request for service is somehow in perpetuity and there never has to be any update. I have one copy service in particular that sends what I believe to be quarterly or set periods for subpoenas. So in other words, every 3 months we see a subpoena, same location, just a request for updated records. Subpoenas for the IMR process, again, despite the defendant providing records and despite all updated records being provided. General or generic or overly general affidavits. Now, CCP 1985 requires some specificity to the request, including what's the exact matter and materiality of the request. The most common affidavit or declaration that I see is issues at hand, including IMR process or UR denial. But again, at the time that that subpoena is requested, is there actually a dispute going on at that point in time? Most of the time it isn't. And if they have a generic or overly general affidavit, they are not supposed to be able to then issue a subpoena, and it's not necessarily subject to reimbursement. Subpoena is issued at the request of new counsel. This is a big one. I once had an attorney tell me that they have a right to issue a subpoena for former applicant attorney's file because it's not actually the proprietary information or proprietary information or documentation that the applicant should actually have access to. And in my opinion, that doesn't make any sense because I responded with, well, what happens if the applicant doesn't get another attorney? What if they're representing themselves? Would they somehow be denied their own file? I have never had a judge tell me that an applicant does not have a right to have access to their own file materials. There may be some questions about whether or not the medical records are appropriate for the applicant to review. There could be some issues with regards to, in particular, psychiatric claims, but long story short, I think it's improper for an applicant attorney just to automatically generate a subpoena without even attempting to even reach out to former applicant's attorney. Multiple subpoenas for the same location. We get one for billing, one for studies, one for different departments. Are they actually necessary? I have had subpoenas issued to locations where I ask for everything in one, and they give me everything in one. What I call mirror subpoenas. We issue a subpoena for 3 locations. They turn around and issue a same subpoena for 3 locations. Subpoenas for unnecessary locations. Again, I mentioned one where they were asking for pediatric records. I have one right now where we have a knee injury and they're seeking gynecological records. I have no idea why that would be relevant, but yet they've issued a subpoena. Also, subpoenas issued in the face of pending litigation on the same topic or subject, where we actually have a hearing set or a trial set over appropriateness of subpoenas, and then they turn around and continuously supplement those subpoenas with additional ones. Additional tactics include improper service. Sometimes the defense counsel receives, sometimes the claims administrator receives, sometimes they both receive. Errors on proof of service. Again, I mentioned a big one that I had where I was able to use an error to our advantage. And then reliance upon the WCAB to enforce payment. I have always told my examiners that the defense side is the one that has to know everything. We have to know the law, we have to know the labor code, we have to know the case law. There are a lot of great applicant attorneys out there that know just as much, if not more, than a lot of defense attorneys. But they are also making the emotional argument when it comes to benefits. My client needs benefits because he can't pay his rent. The defense side is he's not eligible for those benefits because of X, Y, and Z, failure to provide, medical reporting, failure to show up to evaluations, so forth and so on. So copy services are very similar because, well, the applicant has a right to discovery. And the defense side is that right is not unfettered, and here is why, X, Y, and Z. We know that lien trials have low priority. We know that judges don't necessarily like litigating lien issues. We know that there's often confusion with what exactly happened and when and who objected and who made the request and so forth and so on. So they rely upon that to try to wear the defendant down to negotiate when in fact we should be taking those things to trial. Real briefly on reasonableness of charges. One example, does a spliced image count as a different page? You have an MRI with 1,000 different splices. Does that count as a separate page? For each of them, it's unclear. If we have a cancellation charge after we meet and confer with the applicant's attorney and they agree that the subpoena is improper, I would argue that that's not reimbursable. Billing for fees for records from EDD and WCRB, that's no longer allowed, but I still get bills that actually show they are requesting that information and seeking a bill for it. Blanket billing for IMR submissions and billing, and even in the event of an order quashing subpoena, I've had those where they will actually still submit a request even if a subpoena has been quashed. So, best practices. Number one, address the subpoena timely. Business records allow for a minimal of 15 days after issuance of the subpoena. Get your objections in, potentially get your petitions in by that time if it's at all possible. You need to confirm that we have proper service. Were we actually served with a proof of service? Is the request a valid request? Are there issues with the subpoena itself? We've talked about most of those already. And we need to note all potential objections and defenses. I've just listed a couple of them. Duplicative, burdensome, another source, expense, they're requesting privileged records, the subpoena itself is defective, and then there's a vague description or basis for the subpoena. We need to confirm if the timeline for response is proper. Sometimes we'll get copy services that will issue a subpoena and ask for records 10 days later. Sometimes they will immediately call and say, hey, we want to come out, tomorrow or next week and get these records. A lot of the times they will do that because they actually want to get the records and then say, well, there was no objection within the time frame. Yeah, it should have been a little bit, we should have been a little bit slower, but we're just being diligent and therefore you have to pay us. We also need to verify if a notice to consumer is provided, if personal records are being sought by the applicant. This is a big one. An applicant has a right to object to a subpoena, even if it comes from his own attorney. And if there are some very personal or potentially privileged records that are being sought, was the applicant served with the subpoena and given a right to issue an objection? It does not happen too often, but I have had that happen before, where we have had an applicant that did not want records of a very personal nature to be subject to review. And so even with their own attorney making the request, they actually did issue an objection and that subpoena was blocked. This is very important on subrogation claims when the employee has not been not intervened as a party. So for example, the defendant is going against the defendant in the civil claim. Always issue an objection at minimum. You're supposed to offer a meet and confer in said objection and follow-up. This is a big one. A lot of times defense attorneys fail to note in a request for meet and conferring. That is a quick way to get a subpoena or a petition to quash rejected, as well as potential costs. We want to make sure that we include applicant attorney in our objections. We also, again, want to make an attempt to actually contact them. Pick up the phone, say, I've got this dispute, I'd like to resolve it informally with you. If we've got a reason to be partially compliant with the subpoena, then be partially compliant and object to the remainder. And then again, verify the affidavit and declaration. In the event of an electronic signature on the subpoena by applicant attorney, you can ask for a copy of the document allowing for the same. This is something that's really not used too often, but I use it quite a bit. The rules of court indicate that if the declarant is an electronic filer, and most subpoenas have electronic signatures, their signature must be unique to them, capable of verification and under their control. So that means that they would have at some point in time have to sign a physical form, and we have a right to demand production of that original signed document, which means I am simply asking you to verify that you were authorized copy service to provide this subpoena and attach that electronic signature at the request of applicant's attorney. It's a very simple request, but I cannot tell you how many times I have had litigation over that issue. But according to this rule of court, we are authorized to ask for that information. We're simply asking the copy service to verify that they are authorized to provide the service that they're claiming. If we have to file a petition to quash, even if we don't file one, I argue that it doesn't waive our objections later. Sometimes I have examiners that say, no, just issue an objection. we have to state a specific legal right, and we have to note all objections. Simply saying that there is an irregularity on the subpoena itself is not sufficient. We have to argue no good cause, argue duplicative discovery if that's relevant, and again, include that declaration to meet and confer. If the appeals board denies a petition to quash, that does not necessarily equate to responsibility for payment. I've had a lot of lien claimants representatives that claim that, oh, the court denied it, therefore you have to pay it. No, most of the time it's denied because they're saying, well, they can go out and get their discovery, but that doesn't necessarily mean that we have to actually pay for it. I have a couple of judges up here in Northern California that I know if a petition to quash lands on their desk, they will say, no, I'm not allowing that petition to quash to be approved. I'm not going to issue an order, but that doesn't mean the defendant has to pay for it. Take it up later.
Tim, we are at time. However, we did run a little long this morning.
Sure.
With the other webinars. So go ahead and finish it up. I just wanted to let people know that we probably have another 5 slides. So I hope you can stay with us. Otherwise, you will be receiving your certificate if you have to leave.
Yeah, there are just a couple of left and we can get through them pretty quickly. Best practices in regards to filing a protective order. Again, look at the California Code of Civil Procedure that outlines that. The WCAB may accept it or deny it, but a word of caution, if there is a protective order that is filed that is not accepted or not approved by the appeals board, that could result in sanctions unless substantial justification or circumstances warranted. So that's kind of an extreme measure, but be careful with exercising that right. Comply with the non-IBR process. If there's another hearing, sometimes we have hearings and we can't file a DOR for the non-IBR process. So I will file my petition, but I will specifically note in the petition, there is another scheduled appearance. I cannot file my DOR in full compliance. I'm just letting the court know. If a lien conference is filed, I will request a petition from them so I can actually serve the documents on them because they are a non-physician lien claimant. I will try to avoid any of the delays that they may implement by waiting until the appearance, then making the demand, and then being slow in their response, things of that nature. Complete timely file and serves well in advance of the hearing, and potentially list witnesses, including copy service employees, if we have serious questions as to the validity of that copy service, and we may have costs and sanctions on the table. Do not be afraid to set matters for trial. Claims examiners, I was a claims examiner once. I know sometimes it's like, well, if we just pay this lien, we can be done with it. I can move on to the next claim. I have 150 cases and I don't want to deal with this one. I totally get it. But the best way to curb bad behavior is to address the bad behavior. And lien claimants will remember the examiners that will fight and the attorneys that will fight. And so even later on at another case, if you want to negotiate, they will remember that as well, and it usually makes it a little bit easier to negotiate. Finally, consider discovery against the copy service provider. Again, we talked a little bit about that with the signature. What's the agreement that they have with applicant attorney? Do they have the requisite authority to actually pursue the copy services? Treat a subpoena, again, as a request for documentation. Serve updated records. Ensure that your EORs are in line with the appropriate statutory language. If you have any questions, reach out to your attorney. If you do write that written objection, make sure it has all the trimmings of what an EOR would normally have on it. Make sure that your attorney has a copy of the subpoena. Even if it looks like they may have been served with it, email it over to them and say, hey, give me a call. I need to discuss it. And direct copy service inquiries to your attorney. So if you have any other questions, my contact information is right here. I do take phone calls from people that I have no cases with. I answer emails, and I'm happy to do that here.
Well, thank you so much, Tim, for all that information. I think the little bit of extra time that we had was well worth it. There was great information in there. I'm going to encourage everybody to watch this again on our YouTube channel and watch the previous one also, because I think there's just so much information that was provided by both sides. All right, well, we have one more webinar for the summer school series, and that's tomorrow at 1:30. If you have not yet registered for that, please do so on the MacroPro website. It is on acute inpatient care. Until the next time, again, thank you, Tim. Thank you, Jennifer. We really appreciate you being with us and giving us your expertise. We will see all of you again soon. Bye-bye now.
Diane, thanks everyone.
Thank you.
Bye-bye.